And now it's my pleasure to introduce our two speakers today, Dr. Brock Bordelon and Dr. Donald Lefkowitz. Dr. Bordelon is the medical director here at the Hardenbergh Group over Surgical Services. He brings more than 30 years of clinical practice and hospital management experience to his work with physicians and hospitals nationwide. He has experience in performance improvement, peer review, OPPE, FPPE, management of deficient practitioner performance, and external focus review. Dr. Bordelon was a member of the Colorado Medical Board for 4 years and served as chair of one of the board's inquiry panels. Dr. Lefkowitz is our executive medical director here at the Hardenbergh Group. He brings over 40 years of clinical practice and hospital management experience to his work with physicians and hospitals nationwide. He has served as a member of the Hospital Board of Trustees, president of the medical staff, chair of the credentials committee, chair of the peer review committee, and he has supported hospitals and medical staff functions by chairing fair hearings, providing crisis management, press interactions, and developing and nurturing physician leadership programs. Dr. Lefkowitz is the immediate past president of the Colorado Medical Board. So we're very, very excited to have both of these presenters here with us today. They've got a lot of amazing information for you. Before we do kick things off, I do want to let everybody know about a new series of webinars we have coming up. We'll be launching in the next month. We're really excited to announce this. It's our Physician Leadership Education Series. So we'll be offering live and recorded webinars featuring content developed specifically for physician leadership and offering CME credit. So please watch your email next month for details. And we really, really hope and encourage you to invite your physician leaders to attend. So thank you so much. Now I'm going to go ahead and I'm going to turn it over to Dr. Bordelon and Dr. Lefkowitz. And Dr. Lefkowitz, I think you were going to kick us off.
Great. Thanks so much, Sharon. And thank you, everybody, for joining us. We're honored to be able to speak to you today about state medical boards. One of the things that Sharon mentioned that Brock and I have in common is that we both spent time on our Colorado Medical Board. Brock was on the board for 4 years. Somehow or other, I managed to forget to not sign up for my second 4-year term, and I ended up being on for 8 years. And I'm just joking. It was an honor to be able to serve. But during that time, so we have a combined 12 years of service on the Colorado Medical Board. And we realized with that in common that we have lots of thoughts and insights into how state medical boards function, their impact on physicians, hospital staffs, medical staff office professionals. And we thought it would be an interesting topic to talk about. And obviously we had a good response to the webinar. So it seems like you're interested in hearing about state medical boards as well. One of the things that I've noticed over the years when I mentioned that I'm on the medical board, I'm now president of the medical board, is I get a fair amount of raised eyebrows because in general, state medical boards aren't necessarily seen in a very positive light. And in fact, just a quick story, I was a speaker at a chief medical officer boot camp on the West Coast, and I was there to speak about invigorating hospital peer review processes. And the speaker just before me, I was sitting right in front because I was the next to go. And the speaker just before me was an attorney for a state medical association talking about risks for physicians, malpractice risks, license suspensions, things like that. And she spent a good 10 or 15 minutes totally bad-mouthing state medical boards. Basically, her premise was state medical boards are out to get doctors. They don't act ethically. Don't say anything to a state medical board that you don't have to. Always have a lawyer to represent you because they're just out to punish you. And I'm sitting right in front. I'm sort of I can feel my face blushing and she would have no idea of knowing, I was there to talk about peer review. She would have no idea of knowing that at the time I was president of our state medical board. And so I was a little uncomfortable. And I was thinking of ways that I could fit into my talk, sort of a comeback about the fact that actually state medical boards do a good job, generally speaking. So when it's my turn to speak, I went up and she was still in the back of the room. And I started my talk by introducing myself as an emergency physician here to talk about peer review. And I'm currently president of the Colorado State Medical Board. And I looked in the back and she looked back up at me, sort of quickly picked up her things and exited the room. So with that in mind, just as a quick story, our goal today is to demystify some of the misconceptions about state medical boards, what they do, what they don't do. And I would just premise all of our comments today by saying that my 8 years on the board with physicians, public members, PAs, I was incredibly impressed by their dedication to doing what is right. Their mission, as Brock will tell you about shortly here as we start our content, their mission is to protect the public. But beyond that, we always looked for ways to intercede with a struggling physician, to look for ways to rehabilitate that physician to get back to a safe and healthy practice, or the term that we use, most state boards use, to back to a practicing with reasonable skill and safety to patients. Because with physician shortages and things like that, the state boards are not looking to get physicians out of practice unless there's an absolute compelling reason for public safety. And so, with that as a background, I'll turn it over to Brock, and we'll be going back and forth. And please do put in questions in the Q&A column. We're happy to try and address as many questions as we can when we wrap up, and we're looking forward to diving in. So, Brock, I'll turn it over to you.
Great, thanks, Don. I'd like to echo, our thanks for the interest in this topic, because it's something that means an awful lot to Don and I. I was very humbled to have the opportunity to serve on the state medical board, and it was one of the most meaningful things I ever did in my career. We've got a lot of ground to cover. This is a very deep and broad topic, and so bear with us as we're going to race through particularly some of these early slides, but we really want to make sure we hit the highlights of what's important in how a state medical board functions. So just starting off with, how in the world do we have a rationale for having state medical boards? And it comes out of the Bill of Rights, which basically states in the 10th Amendment that the powers that aren't delegated to the U.S. government are not prohibited by the states. In other words, it's the state's responsibility to establish laws and regulations that protect the health, safety, and general welfare of the citizens. And medicine is regulated simply because incompetent or impaired physicians are a risk to the public. So every state, District of Columbia, and the U.S. territories all have medical practice acts that establish state medical boards. And they define the practice of medicine and delegates the authority to enforce that medical practice act to a state medical board. The Federation of State Medical Boards is essentially a conglomeration of all of our state medical boards. And there are 71 boards that are included. That means that there are separate boards in some states for osteopathic physicians. By and large, that practice is slowly going away, and most osteopathic and allopathic physicians are governed by a single medical board, but that's not the case everywhere. Most boards also license and regulate other providers. Physician assistants, nurse practitioners are generally managed by the nursing board, but anesthesia assistants, et cetera, are oftentimes covered by the state medical board as well. The FSMB is the parent organization for the Accreditation Council for Graduate Medical Education. So it's heavily invested in that process, and also sponsors the U.S. medical licensing examination along with the National Board of Medical Examiners. So who participates? Who gets involved in a state medical board? Almost universally, medical boards are made up of volunteer physicians and volunteer members of the public, generally appointed by the governor. It's sort of surprising when you get asked to be on the medical board. Would you like to be involved? That you have to wait for a political appointment, but that's typically the case. The vast majority of the boards have non-physician public members, and they come from a wide variety of backgrounds. Some are real estate agents, some are attorneys, some are people who had spent time on hospital boards, but people who have a deep interest in making sure that the care that's delivered in their communities is as good as it can possibly be. There's a lot of staff that helps out the board members. There's an executive officer. There are state attorneys involved in medical board processes. There are investigators. There are licensing specialists. Sometimes these staff members are shared between other state regulatory agencies, but by and large, most are independent and maintain all licensing and disciplinary powers that are granted to them by the Medical Practice Act. I need to say a word about the state attorneys that are involved with medical board activities. They represent the medical board and the state. So in other words, they're there to represent the public and the medical board when dealing with physicians. They may act as the general counsel for the board when the board has questions about particular actions and decisions that they may be making. And when there are appeals involved, they can act as litigation counsel on behalf of the board. And this all falls under something called administrative law. Administrative law is not the Lincoln lawyer. It's a very different set of rules. It basically is the part of the law that governs activities of administrative agencies within the government. So any government agency, whether it's the medical board or other similar agencies, can include rulemaking, adjudication, or enforcement of specific regulatory agenda part of their purview. And that's actually a lot of what medical boards do. They do rulemaking. They adjudicate cases that are brought before the medical board, and they enforce policies that are generated by the medical board to ensure that patients receive safe and effective care. Administrative law is a completely different set of operating principles than what you normally see in courtroom dramas. And the administrative law judges have significant leeway in how they make their decisions, and they are heavily involved in the appeals processes. So obviously, you can't have a license to practice in a state without having a license granted by the state. And that license is granted by the state medical board. So when an application is sent in, the board staff initiates a primary source verification process. Make sure that the physician has a medical degree. Make sure that they've passed their USMLE or COMLEX. Have they undergone any postgraduate training? We do an FSMB disciplinary data bank, and most importantly, an NPDB sweep to make sure that there are no outstanding issues that need to be brought to the board's attention. The physician's responses in the application need to be evaluated for inconsistencies and red flags. Most states require a background check and fingerprints. And occasionally, depending upon the application and the applicant's history, the board may request a personal appearance before them to discuss issues that arise within that application. Confirmation of the USMLE or COMLEX passage is important because those are time limited for passage, but the time frame that's required per state varies. Some have an unlimited time frame for passage, and some have a 1 to 2 year process. So depending upon state statutes, how that is evaluated is highly dependent upon whether or not that physician has been given enough time to pass their boards. For folks like me who are heavily seasoned, more with salt than pepper in their hair, the National Board of Medical Examiners parts examination, or the flex exam, which is what I took when I was licensed initially in Texas, are still valid for application for state medical board licensure, but those are gradually being phased out as physicians of our era are no longer being licensed. Postgraduate training requirements also vary strongly state by state. Most require a bare minimum of 1 year. Some require none. Some require 2 to 3 years, particularly for international medical graduates. And then the process of license renewal is also very similar to the initial process. A new application is done. This is generally done biannually. An NPDB sweep is performed. A data bank query is performed. A criminal background check is performed. Has that physician performed appropriate numbers of CMEs? Are they continue to be board certified? And then re-verification of personal information. It is very typical for physicians to move practices, change addresses, and not let the medical board know about it. And that can be a cause for issues when they're for license renewal.
Yeah, and that's an important point. And when we talk about complaints, we call it a 30-day, meaning you have 30 days to respond. And the response, if we don't get a response, then we start an investigation and perhaps even a suspension of a license. And it's because they didn't notify the board of a change of address, and we get back, several months later, oh, I forgot to tell you that I moved. I never got any notice from the board, and that's not an acceptable excuse. And so that's problematic. So notifying the board when you change either your practice address, your mailing address, your home address is an important thing. The other thing I wanted to comment on in terms of evidence of ongoing practice activity, CME board certification, many states don't require either CME or board certification. And so it varies from state to state. The implication, I think, for medical staff professionals is that there is a little bit of a reliance on state medical boards for hospitals to have a more rigorous approach to credentialing and privileging than just having an active license, an unrestricted license from the state. And so, I think it's important to recognize that having an unrestricted license from the state doesn't necessarily check all the boxes that medical staff professionals and credentials committees need to check in order to credential and privilege physicians requesting privileges at your facility. So
it's an excellent point. And this happens over and over and over again throughout the physician's lifespan as a practicing licensee within the state. And so every couple of years, the same process occurs. And when somebody has gone along for 10, 15 years, they sometimes sort of forget to keep the board up to date with all of their information. And it's really crucial that they do so. There's some other issues that come up sometimes that boards have to deal with. What about training licenses? So graduate from medical school, you get your MD, your newly minted physician. How do you practice? And that process is, again, regulated by statute and by policies that are generated by the medical board. And it varies state by state. You need generally confirmation that parts 1 and 2 of the USMLE or COMLEX have been passed, and evidence of active supervision in a training program in order to have a training license, and of course, background check and fingerprints. A little bit different processes for international medical graduates, and that's generally spelled out, again, state by state. Some states allow what are called distinguished foreign professors to come in and be visiting professors at their university training programs, and they typically have a little bit of a different licensing process as well. Licensure reciprocity is something that's gaining steam gradually with the Interstate Medical Licensure Compact. There was a big push 10, 15 years ago to consider nationwide medical licensure. I think that that's gradually falling away, but many states have agreed to participate in a reciprocity program that allows individuals, say from Texas, to obtain a license in Oklahoma by basically submitting the same an Oklahoma application, meeting Oklahoma's state licensure requirements, but without a whole lot of rigmarole going back and forth. And this is extremely helpful for physicians that perform locums, or folks like radiologists who may read images remotely in multiple states. Having individual licenses through the compact can be very helpful. Here's where the rubber meets the road: board complaints and discipline. In general, complaints arrive to the medical board via mail or email. You can't make a phone call and say, I need to make a complaint about a physician. They need it documented in either electronic ink or real ink. Anonymous complaints generally are not going to be considered depending upon state policies. And when a complaint arrives, it initiates an investigation. State medical boards are responsive in nature. They don't go out and investigate physicians willy-nilly. They have to wait for a complaint that comes in, and then they're generally required to investigate that complaint. And that starts with a 30-day letter to the physician. And we call it a 30-day letter because it says within 30 days, you need to respond in writing to us. It will outline the complaint. It requires that timely written response. And Don was talking about how important it was to maybe not have attorneys involved. Many physicians will receive a letter like this and feel personally attacked and write on their own something that may come off as defensive or angry. And so having an attorney help draft that letter, that initial response, is very helpful. Plus, again, there is an administrative law process to this. Medical board staff members are looking for certain things within that letter.
Yeah, and that's for sure. And I'll tell you a quick story in a minute about a response we got without an attorney helping draft the response. But it is very important to recognize that state medical boards are 100% complaint driven. So there's no ongoing policing or investigating of the general populace of, Colorado has 35,000 licensees that we oversee. I think we were in New York recently. I think New York has over 100,000. There's really no mechanism or budget to do general policing. So being 100% complaint driven sort of limits our scope of impact on physicians in general. But in terms of a response, the 30-day letter says you need to respond in 30 days. You have to be timely. And you should engage. Many malpractice companies who insure physicians will provide for an attorney to help a physician draft a response. We got a response from one physician who had a complaint that seemed like a fairly substantive complaint. And they got the 30-day letter, and we got a typed on their office letterhead response that the physician himself signed. And the basic tenor of the response was, who the heck do you think you are telling me how to practice medicine? And it was hard to resist not picking up the phone and calling him and saying, oh, we give you your license. That's who we are. I mean, they were completely clueless. You know, they were insulted. They were defensive. They thought they were doing fine. Obviously, not a great way to start your interaction with the state medical board, to accuse us of interceding where we have no authority. But so yes, having an attorney help draft a response is entirely appropriate and advised.
I will be honest, when I very first received a letter from the state medical board many, many years ago, I hadn't been in practice very long. I just assumed I should write the response myself. And probably didn't do a very good job of it, although eventually they were happy with the response. But an attorney can be exceptionally helpful. So as Don was saying, medical boards are complaint driven. And how does that affect the licensee's medical practice? And what happens with spurious complaints? They have to be investigated. There's some other complaint origins that happen. So NPDB triggers. So most state medical boards have an ongoing query of the NPDB. And when there's a malpractice settlement, policies may outline whether or not these require opening a new or reopening a prior investigation of that event. So sometimes issues that arise with a malpractice settlement are already known to the board. Actions that are taken by other state medical boards, including a decision to not grant a license to an applicant, can trigger evaluation by your board. And oftentimes in that situation, there may not be any action taken by the state if that individual state's license is already expired or is inactive, but it will be kept on file in case that physician requests reactivation or relicensure. Any criminal background findings that arise during license renewal, the boards don't do an ongoing sweep of criminal background issues. So some physicians, who we'll talk about later, are required to report, say, a DUI to the board, and do not do so when they come up for a license renewal. The board will discover that, and that triggers another investigation process. And then loss of hospital privileges is a very difficult issue, but when physicians have their privileges revoked or significantly restricted, that's reported to the board as well as to the National Practitioner Data Bank. Sometimes that's a negotiated process. And so when physicians leave the hospital, it's actually not reported because it's being deemed a voluntary withdrawal.
Yeah, and there can be tension between the board and the medical executive committee of a hospital or medical staff leadership on that very point. What needs to be reported, what doesn't need to be reported. We're going to talk in a little bit more detail about that. But we always, neither Brock nor I are attorneys. We always recommend that you keep your hospital attorney involved in situations where there may be some restriction of privileges versus a voluntary withdrawal of privileges. When should it be reported? When does it not need to be reported? We're also going to talk briefly in a little bit about voluntary reporting to your PHP and what value that has to the physician in terms of keeping things confidential from the board under some circumstances.
So when this complaint process gets underway, the board investigators get involved, and they may obtain available records. They have subpoena powers in general. They'll speak directly to the complainant and any others identified within the complaint, witnesses, other treating providers potentially. And in certain circumstances, when issues of significance are discovered, they may widen the scope of the investigation, triggering additional complaints, another 30-day letter, et cetera, requiring additional responses. So depending upon how severe the issue may be, the state investigators have latitude to dig deeper.
And I'll give you another story. One of the most uncomfortable situations I ever had during my tenure as president of the medical board was when we had a complaint from a psychiatrist who was seeing a female patient, and I'll try and keep it G-rated, wildly violating boundaries during each of their psychiatric sessions, for which he continued to bill insurance, by the way. And of course, when he went to break off the relationship, the patient complained to the board. So that's how we generated an investigation. And I didn't know we had investigators that acted like private detectives. They actually placed a wire on the patient, who set up another meeting with the psychiatrist, recorded it, luckily just voice, not video. And we had to listen to that. I mean, talk about uncomfortable feeling. And so their investigation capabilities are quite broad if there is a concern about public safety, which obviously was the case in this. And this physician ended up losing their license and knew that that's what was going to happen once it was discovered. But the investigatory capabilities of the board are substantial if necessary. Again, the goal being to protect the public. I hope I didn't offend anybody by that story.
So once all that information's gathered, it's submitted to the board members for review. The complaint itself, the response, any investigatory information. The board may dismiss this, and it may consider taking further action. Sometimes the complaint itself is tabled with a request for expert review, and the expert is typically another physician licensed within that state in the same training, who's in good standing with the board. It's not meant to be sent off to the world's expert in left great toe surgery. It is designed to be other practicing physicians who would evaluate this physician's care as being something that met the standard of the community and was reasonable. A final decision in that situation is deferred until receipt of the outside opinion. So the decisions really come down to, were there violations of the Medical Practice Act? So the first issue is, was the care acceptable? And that's the primary concern of most board complaints. Was the care that was delivered by that individual who's being investigated and evaluated reasonable and acceptable? There's a whole host of other unprofessional conduct that the board has to oversee. Abuse of a patient, poor record keeping, which can be a danger to patients, not recognizing or acting on common symptoms, basically kind of being a bad doctor, poor prescribing habits, inappropriately delegating the practice of medicine to an unlicensed individual, or inappropriate supervision of an APP that's under their supervising capacity, being impaired, failing to meet continuing medical education requirements, being dishonest, being convicted of a felony, performing duties that are beyond the scope of their license.
One of the things in terms of prescribing drugs, especially in this day and age of more awareness about opioid prescribing, and one of the investigatory powers that the board has is to query the PDMP to look at a specific physician's prescribing patterns. So we were able to look at the number of opioid prescriptions a physician was writing to a specific patient or to their entire patient population for a period of 6 months or a year, and got incredibly helpful information in terms of what a physician's problems with prescribing patterns might be. And that's just one of the other arms to our ability to investigate complaints like that.
So then it comes decision time, and there are multiple options. No action, surprisingly, can be somewhat demoralizing to the physician because it's couched in legal language. The letter that comes back says, we've investigated this. It does not rise to the level of taking action against your license. It's a very typical response. That doesn't mean that there was no concern to the physician. It makes it sound like, well, we still have our eyes on you. But that's the way the process generally works. The communication is the same regardless of the merits of the complaint.
And an important point there is if you have physicians who get this kind of letter, and it seems to the physician and maybe to you that this is a completely spurious, bogus complaint that has nothing to do with their patient care, clinical decision-making, or even bedside manner, the requirement of the Medical Practice Act is that every single complaint be investigated. With the possible exception of anonymous complaints, there are some states that give leeway to dismiss anonymous complaints. Colorado's not one of them. But there were times when we would get the same complaint from a patient about a physician over and over again, and the law says they have to respond to each specific complaint, even though it seems like a completely ridiculous complaint. So one of the ways you can support your physicians who get a complaint is to remind them that, yes, it may seem trivial, yes, it may seem completely ridiculous, but you have to respond politely, just the facts, and it will likely just be dismissed.
Another option for the board is to have a private admonishment or a letter of concern. And it basically says, we have a few concerns, not that we're really, oh my God, worried about it. Please don't make a pattern of this. We are going to keep this on file. And if there are other similar complaints, we get to bring it back for evaluation again. Public reprimand or a letter of admonishment is true public discipline. It can be accessed by anybody with a computer. It may be accompanied by stipulations on that physician's practice, or what we commonly refer to in Colorado as a stipulated letter of admonishment. They may have to attend some courses, be evaluated by the physician help program, have a practice monitor, have restrictions placed on opioid prescriptions, etc. Next level of intervention would be probation with some stipulations. A probated license is, again, public discipline. The license may be suspended pending further investigation, and eventually revocation of the license. It's a prolonged process, but the board has all of those available to them and will choose the one that provides the most protection for the patient with the most protection secondarily for the physician's practice. And can that physician be rehabilitated? Sometimes actions have to be taken very urgently. So a summary suspension is sometimes requested due to the immediate risk to the health, safety, and welfare of the public. It can be achieved typically per policy with the board director and the board president alone, with as many board members present as possible, and then brought to the full board at the next meeting. In this situation, the physician has a right to an expeditious hearing to protect their own rights. Sometimes an interim practice cessation agreement can be performed in lieu of suspension. The physician gets a phone call, you're going to be suspended. You may enter a practice cessation agreement in lieu of being suspended while the investigation proceeds.
And this is usually in response to grave impairment on the part of a physician, whether it's medical, psychiatric, substance abuse. It's become clear through a complaint, often from the hospital medical staff, but sometimes just from a patient, that the physician is experiencing very significant impairment to their ability to practice with reasonable skill and safety to patients.
So treatment and monitoring stipulations are for folks who have drug and alcohol related issues. And trust me, this is not a new issue. One of the most famous American surgeons ever, William Stillard Halstead, had a cocaine addiction and then morphine addiction. And obviously Sigmund Freud had his own cocaine addiction issues. When a treatment and monitoring stipulation is put into place, there has to be monitoring that is generally performed by the state physician health program. It is a time-limited process, and sometimes recidivism is not expected, but we know it does occur. And there's a phrase that we use, relapse is part of recovery, but continuing to protect the public is of paramount importance. So if a physician has an issue with relapse during that time of treatment and monitoring, it will oftentimes require reintervention and reevaluation of that treatment and monitoring stipulation, and potentially extending it or strengthening it. So what are facilities and physicians required to report to the state medical board? In general terms, impairment is one of the most important reasons that a report has to be made. Anything that renders a licensee unable to practice medicine, or practice as a physician assistant, or practice as an anesthesiologist assistant with reasonable skill and safety to the patients. It's not intended to compel licensees to report illnesses that are short-term, don't have a lasting impact, won't affect their ability to practice medicine in the long run with reasonable skill and safety. So what are you not required to report? Have appendicitis, come in, have surgery. Obviously, you're not practicing during the time that you're under anesthesia or on narcotics, but once that process has run its course, you're back to work, you're not required to report that. If a physician says, I need to pull back and maybe do less because I'm undergoing chemotherapy, or I had a terrible car accident and I'm going to struggle because I've got a leg with pins in it. That is not required reporting unless there are complications that can eventually cause problems long-term for that physician's ability to practice medicine. Impairment issues that you're required to report are those that we were just talking about. People with substance abuse, physical or mental illnesses that result in a cessation, limitation, or alteration of practices that's required by the hospital, the physician's employer or practice group, or a payer. Anything where a hospital says you're having limitation of privileges, restrictions on procedures, or we're going to require that you have an additional physician consult on all of your patients. Any condition that a reasonable licensee would conclude that would result in the inability to meet generally acceptable standards of practice. And I have seen this, a physician who had to have his practice, his license altered to being only an assistant surgeon because of narcolepsy. What about the licensee, him or herself? Well, as we were saying earlier, make sure that the board has updated information. You don't want them mailing important information and requests to an outdated address. Any conviction of a state or federal offense, any pending adjudication of a no contest plea, disciplinary actions that are taken in other states, medical malpractice claims against the physician for which the physician was found liable, and this is a final order and not subject to appeal, or any surrender of clinical privileges while that physician's under investigation or in lieu of investigation.
And this is another area where you can do your medical staff members a service by making sure they're aware. There are any number of situations where we've seen physicians who have begun an investigation about a case or a series of cases, or perhaps it's behavioral nursing complaints, and they don't like the trend or the way this investigation is going, and they simply think, well, you know what, I'll just resign my privileges and I won't have to put up with this inquiry or inquisition as they perceive it. And that's reportable. And then there's suddenly a report on their NPD report and they are furious, like, well, how did that end up happening? I didn't get any discipline. And they're not aware of the fact that resigning or surrendering your privileges while under investigation is a mandatory reporting event. And if they had known ahead of time, they probably would have taken a different approach rather than resigning their privileges or surrendering their privileges. So it's a piece of information that you might want to share freely, or in certain circumstances you might not want to share.
That's not so freely. It creates tremendous difficulties for that physician going forward. Application for any additional staff membership, insurance panels, etc. It's always there. The other things that hospitals have to report are termination of privileges, evidence of incompetence, negligence, violation of the Medical Practice Act, or unprofessional professional misconduct. If a physician is being disciplined in the facility because of poor conduct and loses their privileges, or it's bad enough that a report needs to be made to the board, you have to report that. Inappropriate relationships with patients, somebody who's got mental or physical issues that keep them from practicing, and obviously impairment from drug or alcohol. So we received a question before the webinar even was put together, and that is, what happens when you get an NPDB report? So a facility reports a physician to the National Practitioner Data Bank. Are they required to report that to the state medical board? So the actual answer to that is yes, but. Yes, physicians are required to report. So if you send a report to the National Practitioner Data Bank, and the data bank generates its initial report, a correction report, revision, whatever, that should be forwarded to your state medical board. The but part comes in that some states have an electronic report forwarding process, but not all. If you're not sure, it does not hurt for you to send that on to the state medical board. They probably already have it. Most of them have an ongoing cycle of review of the NPDB, but it doesn't hurt. And that way you can feel that you've done the right thing to make sure that the state's been warned. We'd like to talk just a minute or two about physician health programs and how they function. It's a confidential resource for physicians and other healthcare professions. who have addictive issues, some psychiatric issues, sometimes short-term psychiatric issues, medical problems or behavioral or other potentially impairing conditions where they need assistance. They coordinate detection, evaluation, and treatment and continuing care monitoring of physicians with these conditions. The coordination and documentation of a participant's progress allows physician health programs to provide to state medical boards and to hospitals verifying a participant's compliant with treatment and or continuing care recommendations. So that's just like that treatment and monitoring stipulation we talked about. We turn that over to the state PHP program to do the board's requested action in treatment and monitoring, because the board doesn't have the ability to do that. Hospitals have the same abilities, particularly when it comes to behavioral issues, if they refer a physician to a PHP program who may have some issues that need to be dealt with.
I would say, overall, and Brock, you can certainly disagree, but one of, if not the most important things that you can do to support physicians on your medical staff who may be struggling with any type of health issue, mental health, physical health, substance abuse, financial issues, marital issues, whatever it might be, that could potentially impact their ability to practice safely, to suggest that they self-refer to your state PHP, because with self-referral comes, in most cases, not all, but in most cases, confidentiality, and then their ability to be assessed to determine maybe there's an untreated psychiatric illness. We've had physicians who are struggling who end up being undiagnosed bipolar, get on medications, and they're good to go. Or there's a onset of a tremor for early Parkinson's, and it's an orthopedic surgeon who maybe shouldn't be doing OR cases but can still do office work or round on patients post-op. But a self-referral to a PHP in most cases allows for confidentiality. Most initial PHP evaluations in most states are free and covered by your part of your state licensing fees. And it's a place where physicians need to go earlier rather than later if they're starting to show signs that they're struggling for any reason whatsoever.
They're a tremendous resource for physicians.
Yeah.
And almost every state, with the exception of Wisconsin, Nebraska, and Maine, have a PHP program. They provide confidential peer-to-peer services, as Don was saying, for folks in need of support. They have a lot of expertise in education and outreach, long-term monitoring of physicians who've recovered from both mental health conditions and substance abuse issues. And interestingly, the data supports that physicians who have been through a PHP program have lower malpractice rates and have good recovery rates, better than the average population. The safe harbor issue that Don was just talking about is really important. So when a physician self-reports to the PHP, they're deemed to be in compliance with their state board's self-reporting requirements. I'm concerned I may have an alcohol problem. I'm going to call my PHP. My state licensure requires that I call the state board and say, hey, I have an alcohol problem. If I self-report to the PHP and I continue to follow with what they're recommending, even if to the point of cessation of practice, I'm covered for that in being in compliance. PHPs do have to report for physicians who are in an imminent threat to patient safety, those who don't comply with their recommendations or requirements, and those who don't cease practice when instructed to do so. They don't work hand in glove with the medical board, and the lines of communication must be clear and unambiguous, but they're a tremendous resource for the medical board as well. So what about MSPs? How do you interact with the state medical board? What do they do different than you? And the short answer is nothing. In many respects, you're in the same business. You're getting primary source verification, NPDB reports, medical board licensure from other states, training program certification, prior hospital privileges, background checks. All that information that's really not available to anybody who asks is gathered by you. It's also gathered by the board. But what you're doing is a broader dive into that verification process than the board can. So the board really relies on hospitals and MSPs to do a little bit deeper checking to make sure that information that they need to get is sometimes passed along upstream rather than coming downstream from the board. So you're going to query the state medical board for initial credentialing and recredentialing, and any disciplinary action mandates full evaluation, including all available state board documentation that can be made available to you. Minutes, if possible. That's not always the case, depending upon the state. And that is the case whether it's your state or another state that physician may be coming from. So any medical board action needs to be evaluated. MSPs help with preparation of medical board complaints regarding a physician or APP. So having all that information at hand, how to report, what needs to be reported, being detailed is crucial. And keeping track of responses to outstanding medical board complaints really kind of falls within the MSP realm. So use a timeline. When the complaint is generated, you probably won't get the response. You likely won't. Somebody else will. When in my time as an interim chief medical officer, I had to make a report to the state medical board using my title as chief medical officer of the facility. And turns out the board communicates directly with me because it's under my licensure. So I have to pass that back along to the facility. You need to make sure that hospital practices and policies align with state board policies and regulations. And in particular, what's become important is to make sure that opioid policies, utilization of the PDMP, how APPs are supervised, those are crucial issues that your bylaws need to match what the state board requirements are at a minimum. You need to understand the hospital's reporting requirements to the board, and your medical staff leadership needs to be educated. And as they turn over, they need to be re-educated. They can become an ally in making sure that appropriate reporting occurs when the hospital administration is either reluctant to do so or really unclear on the process. And remember that significant behavioral misconduct, not responsive to remediation, or just a single outlandish event, and substandard care and other violations of the Medical Practice Act must be reported. This is about patient safety. It's not about our comfort. It's not about institutional discomfort. Board members really rely on hospitals and other entities to report appropriately so that we're not just simply looking at patient complaints, but we're getting information about physicians who need intervention. Medical boards have other functions. Shockingly, people do practice medicine without a license, so they have to regulate that, track those individuals down. They have to engage in rulemaking, often in response to legislative changes. In Colorado, famously, many years ago, there was a passage of law allowing medical marijuana. The law was passed, and then they turned around and told the board, you have to make the rules. Policy creation and implementation of new state laws, licensure of other healthcare professionals, et cetera. Many of these functions require public input. So while board evaluations of individual physicians' care is done in a private and privileged fashion, anything that can affect public policy and how physicians are regulated, et cetera, is done in a public forum. And there are notification requirements, et cetera. And then there's a billion guidelines that boards create. Treatment of family members, office-based surgery. What do you do when you retire as a physician? What happens to your records? What are you required to do, et cetera?
Yes, steps to discharge a patient from your practice is a very specific approach that the board makes guidelines about, because if you have a patient who you're struggling with and you want to discharge them from their practice, you have to do it appropriately in order to make sure the patient has a safe alternative for care. So
I had a couple of case examples that we can go through, but I think we really only have time for maybe one, just as an example of what happens in front of a medical board. And then we've got apparently a bunch of questions to get through. So we'll just go one particular board case example. A physician was cited for a DUI. First question arises, how did we discover this? Was this a criminal background check, or did the physician let us know? Did the physician already report himself or herself to the PHP program? Or do we need to order that physician to the PHP? Is this a first-time event, or was there prior history involved? This might eventually be resolved with a private letter of concern with a treatment and monitoring stipulation. And depending upon the situation, more significant public discipline of the physician may need to happen, particularly if this is an ongoing substance abuse issue that creates a significant risk to patient safety.
And most of your state PHPs have the term treatment and monitoring stipulation. That's what they do. They have professionals who are trained in treatment and monitoring. Monitoring could be daily random or urine drug screens. They can require daily meetings with a sponsor. And so the treatment and monitoring portion of the PHP recommendations are important to support the board in their activities. And the fact that the PHP is doing the daily monitoring and will notify the board for noncompliance, because noncompliance can change the conditions of the stipulations and even lead to a suspension of the license.
So I think everybody in the audience has the idea that Don and I are fairly passionate about this, and we want to demystify this as much as possible. The board is not a black box, and the more people understand about it, the better interactions can be. The question is, why do you become a medical board member? For me, and I think for Don, it was an incredibly educational process. It's very fulfilling and rewarding. But most importantly, it's meaningful to our patients and our communities. It's another mechanism for physicians who participate, or PAs, or for example, who participate on medical boards, to have an impact beyond just their medical practice.
Yeah, for sure. I was at a point in my career where I was beginning to wind down my clinical practice. My kids were out of the house. And, I felt to me, it was a way that I could pay back for the honor that I had of being able to practice in Denver for almost 40 years. And it's a lot of work. And there were times when it was also pretty stressful. I'd come home from a long day's board meeting reviewing 60 or 70 complaints, and I was pretty burned out and sometimes upset, about some physicians. One of the most common phrases in the inquiry panels is, "Wait, they did what?" Because you just can't imagine something happening, and vice versa. Multiple complaints that were really not really of any substance. But when all was said and done, when I finished my 8 years, I was fine with being finished, but I was very glad that I did it, because I felt like it served a purpose, and I felt like it was a chance to give back. And there were 16 members of the board, 10 physicians, 2 PAs, and 4 public members. We had an architect, we had a lawyer, we had a retired judge, we had a psychologist, and they on any given month, they might have 6, 8, 10,000 pages of records to review to prepare for their literally to prepare for their meeting. And they did it all voluntarily and just trying to keep the public safe, but also help rehabilitate physicians. So as Brock said, it was an honor to be able to serve. So Sharon, I think we got some questions, huh?
We do have some questions, and thank you both so much just for all of that information. I think it was really, really valuable. We've had a lot of great comments as well, just thanking everybody for bringing this information to our MSP community. So, but let's get started on the questions. And I will say, we probably do not have time to address everything. So we'll discuss together about some sort of follow-up to get back to you on questions. But one thing is, there was a question about MSPs being on a state medical board. So I haven't heard either one of you say that, but I think if an MSP wanted to be, what would be your suggestion on how they would get involved?
Are you sure you want to do that?
Yeah. I would encourage anybody, regardless of background, who is interested. Public members are crucial to how state medical boards function. They bring up questions sometimes that we aren't really going to imagine. How does a public, somebody who's not a physician, see how this physician's care and behavior? Very, very different sometimes than the way the physicians on the board do. So you would get involved just like anybody else would get involved. Call and ask, how do I become a member?
Great, perfect. Okay, there's a lot of talk, obviously, compact state licensure, and much of the states are a lot of states are joining that. So is that eventually going to be the way to obtain licensure for physicians? Do you see it all going to a compact license?
There's too much invested in state regulatory control.
Okay.
And so I think states want to continue to have that control. What Colorado needs is say very different than maybe Wyoming, which has a much larger rural physician requirement. So everybody's going to be a little bit different. I think that the nationwide licensure is very, very unlikely to happen. Don, I don't know what your thoughts are.
I would agree. I think there's too much too much at stake for each state. I think that making it easier for physicians to license in multiple states, especially with virtual practice now and virtual radiology, virtual neurology, even virtual critical care, I think it's a great answer to those needs. But each state wants to have control, and they should, because it varies from state to state. So I don't think it's going to change.
All right. There was a question about, Joint Commission now moved to our 3-year reappointment cycle, right? But not all the states allow for that. So just someone was asking for your thoughts on how to go about getting the change for those states. There's been a suggestion to contact state legislatures to require them to change the law so that the 3-year reappointment cycle can be implemented. It obviously helps hospitals, I think, greatly. But what do you think about that? Is that the best strategy? Is that the best way to go, state legislature?
Huh.
I don't think medical board doesn't have anything to do with that, right? The licensing board wouldn't have anything to do with the 3-year reappointment cycle. If it's not allowed by the state, that's got to be a legislative issue, right?
Right. And I'd actually be surprised. I hopefully you've already consulted with your hospital attorney. I'd be surprised if anywhere in the Medical Practice Act there is a requirement about what hospital privilege and credentialing policies should be. I don't know. Maybe Brock, you're more aware of something that I'm not aware of. But most states license every 2 years. And then they require or rely on hospital medical staffs to do the credentialing and privileging, which I mentioned earlier, is generally more rigorous than the licensing process. But how often you do that, I'd be surprised if that's actually something, certainly not something that the state medical board would have say over.
Right.
And I agree. I think it would be a legislative issue, but I think I'm not real sure how I feel about that because they're totally independent processes, although they do the same thing.
Yeah.
And it actually may not be a bad idea that your state licensure is done every 2 years compared to your hospital privileging. I think that may not be a bad thought. Sharon, I would like to add one thing. Somebody made a comment about in one of the questions, this takes time, and that was my mistake. I had a slide that I didn't address. This can take months and months and months and months to get a very simple complaint dealt with. And that is a function of the time it takes to do an investigation and the process. When you know a physician is undergoing one of these investigations, reminding them that being patient is crucial is very helpful. Patience is in short supply in every pharmacy I've ever been in, but it is truly the most important thing you need when you're dealing with a medical board. Sorry, I just needed to do that.
Yeah, no, I appreciate that. And we also have lots of questions just related to CME requirements. Is there like a central location to find those CME requirements by state? Sort of this, if it's so hard to find, how do physicians even know what CME requirements they have if the info can't be easily found? Do you know, is it typically right there on the state medical board website? Do they have to go to each individual state? Is there a central location for this information? Do you guys have any idea?
It definitely varies state by state. Curiously, some years ago, the state legislature in Colorado passed a law saying the Colorado Medical Board could not require CME for licensure. I have no idea what lobbying company promoted that law. Didn't seem to make any sense. Of course, some years later, they also passed a law saying that they require 2 hours of every 2 years of opioid prescribing CME. So there's a law that says you can't require it and a law that says you must require it. That's what rulemaking on the board is like. It's a little bit crazy. But each state's board's website should make clear what their own CME requirements are. And sometimes the websites are more user-friendly than others, but you should be able to find out on the state website.
Okay.
The other location is the FSMB website. has direct links frequently to state board licensure requirements and relicensure. So that's another option. It's probably the only catch-all thing that I could think of.
Got it. So during the complaint process, can a healthcare entity like a hospital request the information from the state medical board or a physician about the nature of the complaint?
No,
Okay,
simply
got
stated.
it.
While
Yep.
under investigation, all elements of that investigation by the medical board are confidential and not releasable. And in fact, we get requests from local authorities, police, state police, wanting us to release a file on somebody because maybe somebody's complained to the local authorities, and we refuse. Look, one of the things the board can do is keep what we're learning as part of our investigation confidential on behalf of that physician, at least until a final determination is made. When a final determination is made, if it's a letter of admonition, it becomes public, and then some of the elements that led to that finding are public and discoverable on the medical board website. But until that time, no, it's you can request it all you want. The board's not going to release it.
Okay. Does the medical board, I know you said they query databank. Are they part of the continuous query? Do you enroll folks in the continuous query? Or is it just you're getting a report from the databank? Because that's if you have a reportable event, do you just get the report? Do you know?
Some states do continuous query. I know Colorado, because I'd get a call occasionally from our program director. We just got a notice from the MTVD that
Got it.
a large settlement case on one of our licensed physicians, and we'd started an investigation somewhat more urgently. And I'm not sure every state does that. I think at the very least every 2 years on recredentialing, on relicensing, I mean, they would do a sweep. But
Got it.
my guess is
Probably most do it.
probably
Yeah,
do
I would think
continue.
so as well. So how do you manage a clear reportable event, but the hospital attorney and hospital leadership insist that the event is not reportable? So I'm not sure if that question was intended to mean what does the medical board do, but do you have any thoughts on that?
Do what's right.
Do what's right. Yeah. Which
First
isn't
of
always
all,
the easiest thing, but doing what's right is the best thing.
I would say that most medical practice acts include a provision that physicians are required to report when they have personal knowledge of substandard care.
Yeah.
So that's on a physician, number one. Number two, a hospital attorney and leadership that says a reportable event is not reportable are putting themselves in legal jeopardy for negligent credentialing, because they're going to continue to give that physician credentials. And if something comes out in the future, they can be sued, and hospitals have very deep pockets, particularly larger ones, for negligent credentialing of that physician, even if the issue that brings it to light is unrelated to the event that should have been reported.
Yeah, perfect. I'm going to take just a second to acknowledge, because I think some people are going to drop off. We're going to answer a few more questions, but I just wanted to just talk a little bit about our physician leadership education series. Again, we're going to be kicking that off. Please watch your email next month for information. You can see this graphic here. We're going to have another webinar with Dr. Lefkowitz and Dr. Bordelon talking about state medical boards. Any of your physicians that attend or do the enduring material will get a unit of CME. So please encourage your physician leaders to come. I just wanted to mention that before we lose some more people. And then let's just take about 3 more minutes to get back to some more questions. And we'll try to get through a few more of these. So again, appreciate all these questions and appreciate our speakers going through and answering all of them. So one of the other questions, I think you kind of touched on it, is who the investigators are. Are they paid? Are they volunteer? Do they have a law enforcement background? And I think what you were saying is it's really, there's a lot of resources for investigators when it comes to the state medical board.
Yeah, and they are professional investigators who, most of them have a law enforcement background and have decided to, maybe go to something that they think might be a little bit less stressful, although it's not always the case.
Yeah.
But they mostly, the investigators have some law enforcement background, and they're good. I mean, the stuff that they can dig up is just amazing and eye-opening.
Yeah. Well, and something I think that's really near and dear to all of our hearts is the peer review protections that are out there. So do state medical boards have the same protections? Are those details or results of their investigations discoverable by medical malpractice litigators?
Only when
So, yeah.
yeah.
Only what? Sorry.
When a final determination is made, if it's a letter of admonition that's publicly reportable, and then the information leading up to that finding is discoverable. All the other stuff remains confidential. And we quick. I know we're running out of time, but the board members rightly have some concerns about their own liability, and we're protected by serving in this role. We're protected. I had been off the board for a year now, and about a month ago, I got served papers by a physician whose license I had revoked. I didn't personally revoke it; the board revoked it. But I was president of the board at the time, and he was suing me for $16 million, which was a bit of an eye opener when I got served the papers. It was even more complex because it turns out his son took my daughter to junior prom in high school. So go figure. Like, this is crazy. I wanted to call him up and say, what are you, his name was also Don, like, Don, what are you doing? But in any event, it's already been dismissed because we have no liability. We're acting on behalf of the public interest and public safety. His license had been revoked. So that was reportable, publicly reportable. And there was really nothing he could do to get around it. And luckily it was dismissed because I wasn't exactly sure how I was going to pay him $16 million. But anyway.
Right, exactly. So once a decision has been finalized, then how long does it typically take before a provider receives a letter telling them of the outcome? Because I think one of our MSPs said that they tend to get I never received anything from the board.
It can take a couple of weeks to generate the letter and then send it out with the next cycle. It's not an instantaneous thing.
But maybe 30 days, 60 days at the most type of thing.
Yeah.
Okay.
Yeah.
Okay. Yeah. And then if no action is taken, does a physician still have to answer yes to an attestation question about ever being under investigation by a state board?
No.
No. Okay. No action was taken. They've been cleared. Okay. Is there any sort of time limit on a complaint?
There may be by
I
state.
imagine with like COVID, right? Things kind of got delayed, I would bet, in a lot of ways. So is there generally a time limit?
So there are some limits, just like there are limits depending upon state statute for bringing a malpractice suit. There are limits. You can't say, well, 25 years ago, Dr. Bordelon, took my appendix out and he left me with an ugly scar. You can't really kind of go down that road. You can make the complaint, but it will be dismissed out of hand. And that's part of the issue. Anybody can make a complaint at any time about just about anything. And the board has to do its due diligence. And sometimes the due diligence is to take a look at it and say, well, that's of no concern, next case. And so from a time limit standpoint, there might be a policy, but I don't believe, certainly not in Colorado, that was limited. I think it was just viewed that as, well, that's not timely and no longer relevant.
Yeah. Okay, I think maybe just two more here. What about when a board does issue a private action? Why is that utilized when the information contained could obviously be potentially very important to the public or the credentialing process?
I think it sort of depends upon what a private letter of concern really truly means. It frequently is, this doesn't rise to the level where we're going to be concerned enough to take action against your license. But at the same time, we had an expert look at the care. We weren't really happy, particularly these issues with the care. Be advised that should something similar in the future happen, we're going to look into it more deeply. It's a little bit like a hospital peer review that might be evaluating exactly the same care, saying we're going to track and trend. The hospital has the ability to track and trend. The board doesn't quite, other than with ongoing complaints. So it's not something that rose to the issue of significant concern to take action against somebody's license, but also, hey, be aware, this wasn't something we're real excited about.
Right. Okay, last question, disciplinary action, when it is issued by one state, does it always reciprocate to other state boards where a physician holds a license? Yeah.
Yes.
Yes.
Okay, perfect. Okay, awesome. All right, thank you both so much. We really appreciate it. I just want to remind everybody again, your CE credits will be coming out in your follow-up email tomorrow from the Hardenbergh group. Mayor, thank you for attending email. So again, we really appreciate you joining us today. We hope you encourage your physician leaders to join us for our ongoing series of physician leadership education. And please watch your email for your credits. Thank you so much. Have a great day.
Take care, everybody.
Thank you.